I am Gloriane Blais. We are the 17th of May 2024. Today I'm doing this live because I deposit today an application to leave to appeal at the Supreme Court of Canada pursuant to Section 40 of the Supreme Court Act and the Rule 25 of the Supreme Court of Canada against the judgment of the Court of Appeal of Quebec rendered on March 18, 2024. This application to leave to appeal deposit today. It's follow the hearing in front of the Court of Appeal at the Quebec Courthouse, March 11, 2024, which a lot of citizens support me at the courthouse in March 11. It will be available today or tomorrow, my notice of application for leave, signed yesterday and deposited today, my plaintiff brief, translate by Deep L, though it's not perfectly translate, and it will also available in French, and all the application for leave to appeal. It will there is a lot of volume will be deposited also, but it will be in French for now. I will explain in my brief what I'm doing, what I'm asking to render available in English all the proof. Then today I'm reading. I try to read. I'm not perfectly in English. You can hear. I put a lot of energy to learn English, but it's where I am now. Then I'm reading my plaintiff brief. I'm the plaintiff. Then I'm beginning. Then a lawyer, the plaintiff, the lawyer, it was me. Then a lawyer, the plaintiff seat. Then Quebec Court of Appeal Judge Jean-Louis Baudouin. The first sentence, it's my sentence. What every judge in Canada maintain or must maintain as taught. Then this is the citation of the Jean-Louis Baudouin, ex-judge, previously judge at the Court of Appeal of Quebec. I am an unconditional believer in the complete and absolute independence of the judiciary, which to me is the key to a fair, non-political, impartial, and legitimate system of justice, and thus a prerequisite to the positive public perception of the system. If the day ever came where I would feel this independence to be threatened by the political system, the executive, or indeed even by the public, it will be my strictest duty to resign. End of the citation. I'm continuing to read my brief. In the application to leave to appeal at the Supreme Court of Canada that I deposit today. The plaintiff is not represented in this case, nor in the proceeding below. What kind of justice system do we want in Canada? One that allows judges to protect each other, or one that respects our Canadian Constitution? Do we want to live and bequeath a democratic country, or do we want to live and bequeath only a democratic illusion? The present Canadian case will require great courage and humanistic humility, for the greatest courage and the humanistic humility are necessary to the greatest integrity. The greatest integrity being essential to the effective fulfillment of the judge at the Supreme Court of Canada, I'm talking to your public and constitutional responsibility that you have chosen to assume as a judge within Canada, as a judge within the highest court in Canada, the Supreme Court of Canada, and as a judge within the Commonwealth. Sorry. But before doing so, it is important that the current Chief of Justice of Canada, and is also the Chief of Justice of the Supreme Court of Canada, and my not at the end of the page, I write, or the next Chief of Justice of Canada, if the current Chief of Justice of Canada resign. Then it is important that the current Chief of Justice of Canada assign to this application for leave to appeal, as well as on appeal, exclusively judges who were not judge of the Supreme Court of Canada on July 8, 2021. And my note at the end of the page is, as of today, only 2 Supreme Court of Canada justices have been appointed after July 8, 2021. The Honorable Michelle O. Bonsawin and the Honorable Mary T. Morrow. It is important that the current Chief of Justice of Canada assign to this application for leave to appeal, as well as an appeal, exclusively judges who were not judge of the Supreme Court of Canada on July 8, 2021, the date on which the Supreme Court of Canada failed, the date on which the current Chief of Justice of Canada failed in the judgment of the application for leave to appeal that gave the origin to this case. Then I deposit an application for leave to appeal in March 2021, and they failed at that time, the Supreme Court of Canada, the July 8, 2021. In order to avoid any obvious conflict of interest, it should be noted that the initial of the 3 judges are missing from the judgment of July 8, 2021. All the judges of the Supreme Court of Canada in office on July 8, 2021 are responsible for this judgment of the Supreme Court of Canada, because public institutions in a democracy, as well as the human beings who make them up, must be accountable for their action and omission. Furthermore, in view of the highly elevated national interest of the application for this current application for leave to appeal, the plaintiff, myself, exceptionally request an hearing on this application for leave to appeal, with written and public confirmation of effective security for the plaintiff's personal protection by the Supreme Court of Canada, or failing that or if not, by the King of the United Kingdom and Commonwealth realms, or the Governor General of Canada. Finally, in view of the foregoing statement and the 2 official languages in Canada, the plaintiff, myself, invite the Supreme Court of Canada, or if not, the King of the United Kingdom and the Commonwealth realms, or the Governor General of Canada, to have the present application for leave to appeal translate into English and made available in English and French to the entire world population, including in particular the 14 volume of the original application for leave to appeal. The original application for leave to appeal is the one in March 2021, in order to offer to the 40 million Canadian and the 2,500 million citizens of the United Kingdom and the Commonwealth realms, meaning approximately 1/3 of the humanity, to offer the transparency of the Supreme Court of Canada and incidentally of the King of the United Kingdom and the Commonwealth realms. Let's take a look at some of the Supreme Court of Canada jurisprudential statements. While these principles may occasionally be dated, they have by no means lost their lustre, and even on the contrary, in their essence, these jurisprudential statements have never been contradicted. In 1997, the Supreme Court of Canada, in the reference of remuneration of Judge of the Provincial Court of Prince Edward Island, writing of the then Chief of Justice of Canada, Chief Justice Lamer. Moreover, the Supreme Court of Canada has pointed to the preamble and judicature provision of the Constitutional Act 1867 as additional source of judicial independence. As far as I am concerned, this source, this is the Chief Justice Lamer, as far as I am concerned, this source also underpin the institutional independence of the judiciary. On balance, it is clear that the institutional independence of the judiciary is fundamental to the understanding of constitutionalism in Canada. Reference Cooper. However, the institutional independence of the judiciary reflects a deeper commitment of the separation of the legislative, executive, and judicial power of the state. End of the citation. Previously, in 1988, the Supreme Court of Canada in BCG EU against versus British Columbia Attorney General, under the pen of the then Chief of Justice of Canada, Chief Justice Dixon, and I cite, "It is obstructing or impeding the impartial administration of justice that is the law of criminal contempt. It has nothing to do with the personal feeling of judge. Judge must not use their power in the regard to defend their honor, and no judge should allow his or her personal feeling to come into play." What has happened in this case? End of the citation, sorry, and now I read my own words in my plaintiff's brief. What has happened in this case, which, through its relentless pursuit of every constitutional principle, through its abuse of power at every level, including the ethical level or disciplinary level, is now what happened in this case here, which is now back before Canada's highest court, the Supreme Court of Canada. Is this the last chance for the Canadian constitutional judiciary to regain its lustre, to question itself with integrity and choose justice? Or is this the end of the democratic illusion in Canada? A case which originally began in 2009, where a crown corporation of the government of Quebec, the province of Quebec in Canada, closely linked by law with the political power of the government of Quebec in Canada, a crown corporation of the government hereafter, I will call government in Canada, abused its power, notably financial, by not respecting the government decree to which it was subject and its contract signed with a Canadian citizen. The Canadian citizen, a victim of the government abuse of power, became the plaintiff client, my client, in 2011. The plaintiff having been a lawyer since 1999, myself, since 1999. A case in which the plaintiff, along with her client, built an extremely solid legal case in which several of her expert reports were never contradicted by the government in Canada, including the expert report established the quantum of the compensatory damage. And I cite my words in my brief in March 2021. And the compensatory damage proven at the trial, on which no evidence to the contrary was submitted by the respondent, total in excess of $30 million Canadian dollar. End of the station. A case where the lengthy trial was held in fall of 2020, where even several witnesses subpoenaed by the government in Canada testified that several witnesses testified in favor of the plaintiff's client's case, honest witnesses who didn't want to lie for some, or who were so used to not following the government decree, who were so used to abusing their power that they no longer had any critical spirit toward themselves, toward their own action and omission. A trial that ended with the day of closing argument, with a judge wearing a body injury, a judge who no longer wore the look that the plaintiff had become accustomed to observing during her many years of practice, and even generally during the inquest at the trial. This judge, whose professionalism she appreciates, a judge whose high competence was unquestioned during the trial, as well as in the aftermath in this trial, in a landmark judgment in another landmark case concerning the Lac-Mégantic train derailment tragedy, a tragedy in which the plaintiff was involved on the American side in legal proceeding with her colleague in United States. A judge, the trial judge, who assiduously and intelligently followed and understood the evidence at trial. A judge who, the trial judge, who was the coordinating judge of his judicial district, and upon his retirement from this important position, was honored with the right words by the then Chief of Justice of the Superior Court of Quebec at a ceremony in September 2013, where the plaintiff lawyer was present. A judge who, in rendering his final judgment, notably omit to name numerous piece of evidence favoring the plaintiff client and failed to assess the credibility of any witness in the judgments, because the credible witness all favored the plaintiff client's case. A judge who threw his omission on his final judgment intentionally favor the said government in Canada. This trial judge seriously failed, not because his competence was limited. That's not the point. This judge failed, the trial judge, because of a highly visible lack of integrity in this case, against the aforementioned, against the government in Canada, by a blatant lack of integrity for those taking note of the evidence or having attended the entire lengthy trial. A judge who placed himself in the wrong place in history, for it is important to know our Western history, which is the foundation of our present. As I conclude my argument, my pleading before the Quebec Court of Appeal on March 11, 2024, and it's my station. When you take on a constitutional responsibility like being a judge in Canada, in a country that has to be democratic, it's called itself democratic, and it informs the population that it is democratic, you have, as judge, when you have take on the responsibility of being a judge, to be ready to go all the way in our constitutional responsibility. Otherwise, you don't take them these responsibility. You are not obligated to take them. It's a personal choice to take them. If you take them, you assume them to the end, to your death, if needed be, to the end. When you are in democracy, you are involved in peaceful, non-military process. To answer this process and this peaceful approach, as I am doing today, we have to be capable of going all the way, like the military, like our veteran did in the Nazi era. Otherwise, we have to stop taking democracy for granted. When I was a lawyer, I took a course at the International Law Association in São Paulo, in Brazil, with anti-corruption experts from Washington, Paris, and London, 3. So what I'm saying to you is stop protecting individuals who fail in their constitutional and public responsibility, even if it takes the greatest courage in the world. Ask for your, I'm talking to the judge at the Court of Appeal in March 11, ask for your personal protection. Have the courage to take cognizance with an open mind, because impartiality require an open mind, according to Luc Huppé from La Déontologie de Magistrature. So take cognizance of the open mind evidence required to ensure your impartiality, to ensure that you will fully assume your constitutional responsibility as a mark of respect to the founding fathers and veterans who went to defend our human rights, our freedom, even to the peril of their lives. End of my citation. I'm continuing my plaintiff brief. And what happened as a result of this outrageous lack of impartiality, judicial independence, and the rule of law, as a result of this final judgment with an intentional lack of integrity on the part of the trial judge, who failed instead of taking his cue from our veteran that is following through on his constitutional responsibility. What happened? What happened after? The Quebec Court of Appeal and the Supreme Court of Canada chose to protect the judge who had failed in his constitutional responsibilities to protect their judge friend and then their judge friends, plural, instead of appointing what need to be appointed, instead to acting justly. This is what the application for leave to appeal from the in March 2021. This is what the application for leave to appeal from to the Supreme Court of Canada prove. The highest court in the province of Quebec in Canada and the highest court in Canada have chosen to do what the Chief of Justice of Canada in 1988, Chief of Justice Dixon, warned us about. Beginning the citation, this has nothing to do with the personal feeling of judge. Judge must not use the power they have in this respect to defend their own honor, and no judge should allow his or her personal feeling to come into play. End of the citation. But before the Supreme Court of Canada failed, before the judgment of the Supreme Court of Canada, when the original application for leave to appeal had just been filed with the Supreme Court of Canada, the then Chief of Justice of Quebec, the then Chief Justice of the Quebec Superior Court, meaning the boss of the Quebec Superior Court trial judge, chose not to do what he had to do in order to respect his constitutional responsibility, which was to bring the then exclusively Quebec situation, Quebec Superior Court and Quebec Court of Appeal, to the attention of the Canadian Judicial Council. No, he didn't do this. In order to rightly denounce his fellow judge, instead, the then Chief Justice of the Superior Court of the Quebec Superior Court chose to go from insult to outrage and officially filed a request for an inquiry concerning the plaintiff lawyer with the syndic of the Bar of Quebec, du Barreau du Québec. But there should have been no concern for the plaintiff lawyer because the syndic du Barreau du Québec is an independent institution dedicated to the protection of the public and therefore at the service of a lawyer who denounced with solid evidence the shameful lack of constitutional responsibility of the trial judge of the trial judge of the Superior Court of Quebec and the panel of the 3 judges of the Quebec Court of Appeal. But against all expectation for the plaintiff lawyer, the respondent, Daniel Gagnon, assistant syndic at the Quebec Bar and responsible for handling this request for inquiry from the then Chief Justice of the Quebec Superior Court, decided to bring the first ever lifetime disciplinary action complaint against the plaintiff lawyer. Despite the extremely solid evidence within the 14th volume of the original application for leave to appeal. The disciplinary proceedings were instituted on May 18, 2021, even before the Supreme Court of Canada July 8, 2021 judgment on the original application for leave to appeal in March 2001. Then it's nearly 2 months before the judgment at the Supreme Court. As if the intention had been to threaten the plaintiff lawyer as if to make it clear that it would have to withdraw her application for leave to appeal in order to prevent the Supreme Court of Canada from having to render judgment and failing in its constitutional responsibilities. It should be noted that the respondent Gagnon, Daniel Gagnon, testified under oath on 2 occasions that in addition to the 20, except for the 20-page brief, he had never read a page of the 14 volume of the original application for leave, the evidence, going so far as to plead before the Daniel Gagnon plead before the Quebec Bar's Disciplinary Council, and I quote, he, the respondent Gagnon, pleads that reading the 14 volume of the application for leave to appeal is not relevant to deciding the complaint. End of the citation. While the respondent Gagnon had chosen to assume public responsibility for evaluating the request for inquiry and its evidence, or was it a way for the respondent Gagnon to protect himself from possible criminal prosecution by trying to make people believe in the lack of his criminal intent, in the lack of his mens rea. We have reached the stage where we are entitled to ask ourselves this question. This disciplinary action by the respondent Gagnon was illegally endorsed in a total denial of justice and of the Canadian Constitution by the Disciplinary Board of Quebec Bar, by the Quebec Professional Tribunal, and again by the Superior Court of Quebec and the Quebec Court of Appeal. The Canadian judicial system having failed to respect the Constitution of Canada. As I mentioned before, the Quebec Court of Appeal on March 11, 2024, and it's my citation, for a case in which the Canadian judicial system failed miserably, including the highest court in a Canadian province, the Quebec Court of Appeal 3 years ago on February 4, 2021, and scandalously, including the highest court in a Canadian country, the Supreme Court of Canada, on July 8, 2021, a case in which the Canadian judicial system failed to respond to the Quebec government abuse of power. Today, the only question, Mr. Justice, I was pleading in front of the Court of Appeal, today the only question, Mr. Justice, that you must decide is, who do you wish to protect? The Constitution of Canada, where the constitutional judicial power was interpreted by the then Supreme Court of Canada as being the constitutional counterpower to the abuse of government power, or to protect the individuals who do you wish to protect, Mr. Justice? Who to protect the individuals who have failed in their constitutional responsibility, your fellow judge who have failed. To have chosen not to respect their obligation and constitutional principle, notably the rule of law, the separation of power, the independence of the constitutional judiciary, and the obligation of impartiality of the court and judge personally. On this last obligation, impartiality, please refer to Luc Huppé, monograph, La déontologie de la magistrature, perspective canadienne et internationale. If you want to know more about what an obligation of impartiality is, covers it on several pages. End of the station, my station. It is in this circumstance that the present case concerns not only the plaintiff, but all Canadians who wish to live under the rule of law with a judicial system that respects its constitutional responsibilities. The role assigned to the Supreme Court of Canada is described as follows. The Supreme Court of Canada is the country's final court of appeal. It serves Canadians by deciding questions of law of public importance, thereby contributing to the development of all areas of law in Canada. The independence of the court, the quality of its work, and the respect in which it is held both at home and abroad all contribute greatly to the foundation of a strong, secure, and democratic country based on the rule of law. Under the Supreme Court Act, the Supreme Court of Canada is composed of 9 judges, including the Chief Justice of Canada. The Supreme Court of Canada is an important national institution situated at the apex of the judicial power of the Canadian state. End of the station. The rule of law, this is me, right? The rule of law only exists if the Constitution of Canada is applied by the court. My argument. Question 1. For the sake of the public confidence in the Supreme Court of Canada, the highest institution of the third constitutional power, on this application for leave to appeal and on the appeal, is it desirable to assign exclusively judges who were not judges of the Supreme Court of Canada on July 8, 2021? And the answer, yes. Obviously, to avoid any conflict of interest in connection with his judgment of July 8, 2021, the date on which the Supreme Court of Canada failed in the judgment on the application for leave to appeal that gave rise to the present case. Sorry. Question number 2. Is it desirable to provide for a hearing on this application for leave to appeal with written and public confirmation of effective security for the personal protection of the plaintiff, myself, by the Supreme Court of Canada, or failing that by the King, or if not by the King of the United Kingdom and the Commonwealth Realm, or the Governor General of Canada? Answer, yes, in view of the extremely high national interest of this request application for leave to appeal, all on exceptional basis. Is it desirable to Question 3. Is it desirable to have the present application for leave to appeal, including the 14th volume of the original application for leave to appeal, translate into English and made available in English and French to the entire world population by the Supreme Court of Canada, or if not, by the King of the United Kingdom and Commonwealth Realms, or the Governor General of Canada? And the answer is yes. Given the above statement and the 2 official languages in Canada, in order to offer the 40 million Canadian and the 2,500 million citizens of the United Kingdom and the Commonwealth Realms, meaning approximately 1/3 of the humanity, the transparency of the Supreme Court of Canada, and incidentally of the King, and incidentally of the King of the United Kingdom and the Commonwealth Realms. Question number 4. What kind of justice system would you like to see in Canada? A system that allows judges to protect each other? No. The answer is no. In 2011, in her published thesis, author and law professor Martine Valois present an accurate portrait of the evolution of the Supreme Court of Canada with regard to the judicial independence. And the citation, although Valente had already distinguished between the two aspects of judicial independence, it was in Beauregard that the notion of the independence of the judge became that of the judiciary, which is broader than the freedom of the individual judge. The judgment Interian and Moreau de Berube, in which the court for the first time raised the notion of abuse of judicial independence, clearly demonstrate the desire of the country's highest court to limit the scope of the protection of judicial independence in case where the guarantee must be applied to a judge whose conduct prove unworthy of the office of he or she owed. In a way, the Supreme Court, this is still the law professor Martin Valois, in a way, the Supreme Court is sacrificing judicial delinquency on the altar of institutional independence. This is the price to be paid to prevent the paradox of judging each other from tarnishing the aura of legitimacy that the courts are trying to build on the foundation of judicial independence as a pillar of the justice system. End of the citation. Question 5. What kind of justice system would you like to see in Canada? A system that respects our Canadian Constitution? Yes. Question 6. Do we want to live in a backward, a free and democratic society, democratic country? Sorry. Answer: yes. As a Commonwealth country, we have to fight in the face of totalitarianism and barbarism, even to the point of losing our lives, the many lives of our veterans, to ensure human rights and social peace, because without respect for human rights, there can be no social peace. As a Commonwealth country, we have to choose respect for human rights and social peace through the creation of our public institution, inspired by Roman law, through the creation of these institutions, which are the guardian of respect for human rights and constitutional principle inspired by Roman law, through the application of our Constitution, including the Constitution of Canada. In our public institution, no longer respect their constitutional responsibility if the judiciary is no longer a counterweight to the abuse of government power, if the judiciary serves judge and not justice. Then we can no longer claim to live in a democratic country. And it is not by forgetting the fault that we correct those faults. It is only by the judiciary's sincere, honorable amends that the judiciary will be able to right itself to correct itself, as is the case for every human being. Sincere amends are the only way. Sincere amends are the only way forward for the judiciary, for every constitutional authority, for every public institution, for every human being. Sincere amends. We are capable of doing this as Commonwealth country. We are capable of doing this for the future of our children. Because what the veterans did was their legacy. Now it's up to us. It's up to you, dear Judge of the Supreme Court of Canada, to bequeath a democratic society for the future generation. Question 7. Do we wish to act with utmost integrity? Answer, yes. Question 8. Should the Supreme Court of Canada see this final opportunity for Canadian constitutional judiciary to regain its lustre, challenge itself with integrity, and choose justice? Yes. Last question, question 9. Are the decision and judgment of the Canadian judicial system in the present case, including the original case, on our abuse of power by the third Canadian constitutional power, meaning the judicial power? Answer, yes. Here are the decision and judgment that the plaintiff had to face in the face of this relentless abuse of power by Canada's third constitutional power, that I'm reading all the decision and judgment. First, final judgment of the Superior Court of Quebec, date of November 24, 2020. Quebec Court of Appeal decision, date February 4th, 2021. Administrative decision of the then Chief Justice of the Superior Court of Quebec, date April 15, 2021. It's not finished. Decision to file a disciplinary complaint by the Syndic of Quebec Bar, date May 18, 2021. Supreme Court of Canada judgment, date July 8, 2021. Decision of psychiatric examination, date February 3rd, 2022. And decision of permanent disbarment, date March 10, 2022, by the Board of Directors of the Quebec Bar. Decision on guilt of the Disciplinary Board of the Bar of Quebec, date of April 29, 2022. Judgment of the Profession Tribunal, date August 3rd, 2022. Decision on sanction Disciplinary Board of the Bar of Quebec, date September 14, 2022. It's not finished. Judgment of the Tribunal des Professions du Québec, date February 16, 2023. Quebec Superior Court judgment, date January 3 and 9, 2024. And Quebec Court of Appeal judgment, date March 18, 2024. It is now time for the Canadian Constitutional Judiciary, through its highest court in Canada, to restore justice. Incidentally, the plaintiff and her brief on the original application for leave to appeal as follows. The first sentence is mine. Well, we will end this quote from with this quote from Professor Osger, Enigar, and Riddle. Then I'm reading the quote of these professors. Suffice it to say that independence of the judiciary is an essential part of the fabric of our free and democratic society. It is recognized and protected by the law and the Convention of the Constitution, as well as by statute and common law. Its essential purpose is to enable judges to render decisions in accordance with their view of the law and the fact without concern for the consequence to themselves. This is necessary to assure the public, both in appearance and reality, that their case will be decided, their laws will be interpreted, and their constitution will be applied without fear or favor. I'm ending this my plaintiff's brief, and the plaintiff is myself. And let's not forget the plaintiff, myself. whose unfading integrity led her to be improperly disbarred as a lawyer in Canada. It is now also time for her to benefit from the protection of the Constitution of Canada as a constitution born of Roman law, born of the law of over 2,000 years ago, which we cannot afford to lose through the lack of integrity of the third constitutional power, the judicial power. And I'm finishing with a quote, a citation from the Supreme Court of Canada in Groya and also in Hill versus Church of Scientology of Toronto. A lawyer's reputation for integrity is his most important professional asset. This reputation usually takes a long time to build and can be lost at the snap of a finger. Court and authors have stressed its importance. In the Corey decision, Justice Corey put it this way: a lawyer's reputation is of paramount importance to clients, members of the profession, and the judiciary. Lawyers build and maintain their practice through their reputation for integrity and conscientiousness. It is the cornerstone of his professional life. Even with exceptional talent and diligence, a lawyer cannot survive without an impeccable reputation. Maintaining a reputation for integrity is the challenge of a lifetime. Once tarnished, a lawyer's reputation may never be fully restored. Then the plaintiff requests that her application for leave to appeal be granted. And I signed yesterday and I deposit today at the Supreme Court of Canada. I will deposit today or tomorrow on X and on Facebook these documents in this brief in French and this notice and the notice in French, and I will deposit this brief and this notice in English. And I will also deposit the full volume, all volume of the application for leave to appeal, to this application for leave to appeal, including the 14 volume of proof of the previous application for leave to appeal in March 2021. I will deposit for also on X and Facebook through a Docurium link. But this volume will be only for now in French until the Supreme Court of Canada or the King or the General Governor of Canada translate in English for the Commonwealth citizens, notably. Thank you very much.